Assalamualaikum and a very good morning to everyone. So welcome to Law 107 class, Administrative Law for Public Authorities. Okay, I bet that you guys already watched the preview or an introductory video on Law 107 class. So I hope that you already understood the lesson plans, okay, the topics that we are going to cover during this semester. Okay, and for today, yes, we are going to start with the first chapter under an introduction to administrative law for public authorities. So please bear in mind that this is only an introduction, okay, and after this we will proceed with the next topics, okay, which is main topic of the administrative law. Okay, so these are the learning outcomes. These are the learning outcomes for today's lecture. First, at the end of the lesson today, you are able to describe administrative law and distinguish its scope from other branch of laws and reasons for its growth. Second, you are able to outline the constitutional principles that govern administrative law. And third, you are able to identify the powers and functions of public authorities. So generally, these are the main things that you are going to do in the first chapter. Okay, now let's take a look at the definitions of administrative law. Okay, because before we go beyond of that, we need to understand the meaning. Okay, the legal definition of administrative law. Okay, as we can see here, okay, the first definition is known as the general definition of administrative law. It is a branch of law governing the administration and regulation of government agencies for both the federal and state level. So based on the general definition here, we can simplify it that the administrative law is a part of law. Okay, but the main focus of administrative law is to administer. Okay, so it governs the administration and regulation of government agencies. And the government agencies here can be both at federal or at state level. So this is the general definition. Okay, move on to the next definition according to Hasbury's Law of Malaysia. Okay, law relating to the discharge of functions of public authorities. Okay, so this is the main idea, keywords that you need to learn about the functions of public authorities and officers and of tribunals, judicial review of the exercise of those functions, the civil liability and legal protections of those purporting to exercise them, and aspects of the means whereby extrajudicial redress may be obtainable at the instance of persons aggrieved. So what we can summarize from these definitions? Okay, basically, according to Hasbury's Law of Malaysia, administrative law covers the functions of public authorities and government officers. Okay. Second, it also covers the functions of tribunals. Okay, what is the function of tribunal? To hear the dispute. Okay, so when we prefer to go to the tribunal, okay, we can avoid the court proceedings. Okay, and then judicial review. Judicial review of the exercise of those functions. Okay, so bear in mind functions here referring to functions of public authorities and officers. So the court need to control their functions by way of judicial review. And then the civil liability and legal protections of those purporting the exercise them. Okay, so we also accord legal protections under administrative law. Okay, an aspect of the means whereby extrajudicial redress may be obtainable. Okay, judicial redress here can also be called as a remedies. So we give the remedies to the aggrieved persons. Aggrieved persons referred to innocent party or an injured party. Okay. Okay, next definition according to A.W. Bradley and T.D. Ewing. Okay, according to them, administrative law is a branch of public law concerned with the composition, procedures, powers, duties, rights, and liabilities of the various organs of government which are engaged in administering public policies. Okay, so the keywords based on the third definitions are, okay, administrative law cover all, okay, the composition, procedures, powers, duties, rights, and liabilities. So liabilities of whom? The various organs of government which are engaged in administering public policies. So it seems that it covers all duties, functions, anything that related to the administrator. Okay, administrator. Who is the administrator? Administrator here refer to the organs of the governments, okay, which are administering public policies. Alright, so you can summarize, okay, the definitions, okay, and please remember the definitions in one sentence. This is very important because you need to define administrative law before you start answering the problem-based question method. Okay. Okay, next we move on to the scope of administrative law. Right, you already know the definition, the meaning of administrative law, and then now, what are the scopes of administrative law? So administrative law ni cover apa? Okay, so there are two scopes of administrative law. First, okay, the first scope is body of rules. So it states that administrative law consists of body of rules, regulations, limitations of powers, and orders formulated by a government body or organs of administrations. So the government bodies here include public authorities. In other words, public authorities, okay, will make body of rules, regulations, and also they have the limitations of powers and orders. Okay, so they are responsible for carrying out a particular statute law. Okay, there must be a statute, okay, that give power to this government body to make rules, regulations, orders. Okay. And the second scope of administrative law, as you can see here, it also covers the legal rules and principles used by court to control the exercise of statutory powers of adjudications and rule-making by public authorities. Okay, what you can summarize here is it also covers the judicial review. Okay, because the judicial review or judicial control by court here are based on the legal rules and principles. Okay. So, a court will control the statutory powers of adjudications and rule-making given to public authorities. And apart from that, the legal remedies also given to a person when his rights are infringed by their operation. Okay, so administrative law also accord the remedies to the innocent party. Okay, so there are two scopes of administrative law. Okay, next. What is the rationale for the group of administrative law? Okay, we have the previous situations of administrative law, and then now we have the present situations of administrative law. Okay, previously the state acted more like the police or a law and order state, and its role was limited to defending the country from external aggressions, maintaining law and order within the country. Okay, the main focus of administrative law before is to protect the country. So they are more like a police. Okay. However, okay, at the present situation now, the state assumes a positive role and becomes transformed into an active instrument to promote socio-economic welfare of the people. So, they are preparing to safeguard the socio-economic welfare of the people. And then, at the present situation of administrative law, the state also seeks to promote social justice, and the state assumes many functions which were previously left to be discharged by private enterprise. Okay, so at present situation, they are more concerning to the people. Okay, the welfare of people. That's why there is a need of a judicial control, okay, or a judicial review in order to control the power of a government bodies. Okay. Okay, next. Okay, there are several functions of a modern state. Okay, basically there are 5 main functions of modern state. Modern state here referring to the present situations of administrative law. Okay, first is known as a provider. The main function is a provider, whereby the state seeks to provide social service and minimum welfare to the people to ensure a minimum standard of living for all. Next, known as an umpire. Okay, to discharge arbitral functions between competing interests in the society. Okay, so the main idea of administrative law at a modern state is to avoid the arbitrary, okay, the arbitral powers. And then state as a protector, okay, as a regulator. Regulator means they aims to control the various activities of the community, the economic and social life. Okay, and then the function of state also as an entrepreneur, okay, whereby it undertakes several public undertakings and enterprises. Okay, alright, so next we will proceed with the next subtopics, okay, under constitutional principles.